What are the most common 3 defenses that defense lawyers use in these medical malpractice cases? Anybody know? I'm sure you guys know. You're just being quiet this morning, and that's okay. The 3 common defenses that are often seen is, hey, we didn't do it. That's number 1. Number 2 is, maybe we did it, but you also did it. And number 3 is, okay, maybe we did it and you did it, but guess what? We don't think that your injuries are as valuable as you claim them to be. Those are the 3 common defenses. They're arguing about liability, who's responsible, and then once you get past who's responsible, they're now going to argue about the value of damages. Because even if they accept and acknowledge, which doesn't happen often, that they did something wrong and violated the basic standards of medical care, causing the client harm, they will always, in every instance, fight you tooth and nail on the extent and the amount of the damages. And we'll talk about damages in a little bit. But another common defense that comes up often in these cases is, the doctor says, hey, I use my best medical judgment to decide what to do in this case. Who are you to tell me otherwise? I'm in the middle of surgery, the patient has a complication, I now decide to do the following procedure to fix this problem. Who are you to tell me otherwise? Well, that's why we need medical experts to tell us otherwise, to tell us why this doctor deviated and violated the basic standards of medical care. So that's why it's critical. So now you have competing medical experts that the jury will have to evaluate. But how effective is this argument that's made by the defense? It's a judgment call. Don't blame me. I went to medical school. I did my training. I'm here at a prestigious medical institution in New York City. Why are you blaming me for something that I use my best medical judgment? And you know what? Juries like that argument. Hey, why are you picking on this doctor? He's a great guy. He's got great credentials. What he sounds is what he's telling us is reasonable. Well, that's the inherent problem with a judgment call where they're saying, don't blame me. I had multiple choices. The following were all acceptable choices, but I made a best judgment call based upon the problem that was going on at that moment. So how do we deal with that? We deal with that by evaluating whether or not the judgment call truly was an exercise of the doctor's best judgment. Or did he have multiple choices and the choice that he picked was a departure from the standard of care? Let me give you an illustration of how this works. Let's say a patient goes to a doctor for an opinion about what to do, and the doctor tells her, I would treat you this way. And she decides to go to 4 other doctors to get other opinions. 4 of those doctors tell her, I would treat you this way. The 5th doctor says, no, 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 I wouldn't treat you that way. I'm going to treat you this way. Well, he's clearly in the minority. But he's going to say, hey, this choice to treat this patient this way is within acceptable medical standards, even though it's in the minority. Just because I won't do it the way that the majority of doctors do it doesn't mean it's wrong. What do you think happens? The patient chooses to go to doctor number 5. And you can sense the foreshadowing. She develops a problem and a complication during the course of surgery. She then sues the doctor. And the doctor, in his defense, turns around and says, I exercise my best medical and surgical judgment. Don't blame me for what happened. I did nothing wrong here. And if I did, you also did it. And if I did and you did it, guess what? You're not really that injured, are you? Those are the defenses that come up over and over again. But what happens, though, if the doctor's choice to treat this patient really wasn't within acceptable guidelines, acceptable standards of care? And regardless of whether he was in the majority of the doctors who would do it or the minority, if that treatment fell below the standard of care, the fact that he chose to use his best judgment is not going to work, at least not as effectively as if it really was within the standard of care. Now, here's something that will really help you understand and be able to explain to these people you're chatting with. They don't understand that simply because they wound up with a complication or a problem during the course of treatment or surgery, that it may not be evidence of medical malpractice. From the patient's perspective, all they know is, hey, I was fine going into the hospital. I came out with the following horrible complications. And you tell them, hey, just because you got a complication does not mean that there was evidence of malpractice. It might, but then again, it might not. And they get very defensive. They get very upset because they know in their mind something must have happened. The doctor must have done something wrong. The nurse must have given me the wrong medication. Otherwise, I would not have had these problems. And you know what? Maybe that's true. But in order to answer the question, you have to evaluate, what do you have to do? What was the key issue in the case? What do you think was done wrong? And what injury did you suffer as a result of that? And the next thing you have to answer is your matter timely? So let's say you decide and you evaluate, yes, both of those things sounds like a case, and yes, this matter is timely.